Good morning, ladies and gentlemen. The court meets today to hear oral arguments of the parties in the case obligations concerning negotiations relating to cessation of nuclear arms race and to nuclear disarmament. Let me recall briefly the procedural history of the case. On 24th April 2014, the Republic of the Marshall Islands instituted proceedings against the United Kingdom of Great Britain and Northern Ireland with regard, in particular, to alleged breaches of obligations borne by it by virtue of the 1968 Treaty on Non-Proliferation of Nuclear Weapons and customary international law relating to cessation of the nuclear arms race at an early date and to nuclear disarmament. On March 16th, the court received the memorial of the Marshall Islands, and on December 16th, 2015, the court received the counter-memorial by the United Kingdom. Both parties agreed that there was no need for further written briefs, so I note the presence of the agent and counsel for both parties, and I now invite the United Kingdom agent, which has raised preliminary objections in this case, will be heard first today. I now invite the agent of the United Kingdom, Ms. Syifa Radhiyya.
Mr. President, members of the court, it is an honor for me to appear before you today as agent for the United Kingdom. First, Ms. Agent UK2 will deal with the first and fifth preliminary objections which the United Kingdom has raised in this case, in the order in which they were presented, in our written submission of June 15, 2010. The first exception is that there is no dispute between the Marshall Islands and the United Kingdom which is capable of being the subject of judicial settlement. The fifth consists in stating that, in any event, a judgment of the court would not be capable of effective application and that, therefore, the court should refuse to exercise its jurisdiction in the present case. Mr. President, with your permission, I would ask you to now to call Ms. Agent UK2. Thank you.
Thank you, Ms. Syifa. Now I give the floor to Ms. Syesil. You have the floor.
Mr. President, members of the court, it is an honor and a privilege for me to appear once again before you on behalf of the United Kingdom. Mr. President, members of the court, it is with more pain than anger that we plead today to oppose the jurisdiction of the court in the present case and the admissibility of the application brought by our friends in the Marshall Islands. We subscribe to the goal which is at the heart of their approach, namely to encourage states to further efforts to achieve the objectives set out in Article 6 of the Non-Proliferation Treaty of the continuing in good faith negotiations on effective measures for nuclear disarmament. We also recognize the obligation imposed on us by Article 6 of the NPT as it imposes it on all other states which are parties to it. There is no dispute between the UK and the Marshall Islands. This case should never have gone to court. As these hearings deal with the question of jurisdictions, we will not consider the allegations made by the Marshall Islands on the merits. The objections to jurisdiction and inadmissibility which we have raised are of a purely preliminary nature. However, the Marshall Islands claims that for decades we have shown bad faith in our treaty obligations. In view of the gravity of this accusation, we would like to draw the attention of the court, if only to have this record to the document appearing in Annex 2 to the statement of our preliminary objections, as well as to the statement made by the United Kingdom in the report dated 22 April 2050 on the implementation of the action plan of the Conference of the Parties to review the Treaty on the Non-Proliferation of Nuclear Weapons in 2010. In this report, a document that anyone can refer to on the United Nations website, the UK said it was committed to achieving a nuclear weapon-free world in accordance with its obligations under Article 6 of the NPT and was firmly convinced that the best way to achieving this goal is to negotiate progressive disarmament step by step and within the framework of the UN disarmament mechanism and the nuclear non-proliferation treaty. The United Kingdom remains committed to continuing to work with partners at all levels of the international community to prevent proliferations and to make progress toward multilateral nuclear disarmament, to build trust among states with nuclear power, weapons and those who don't have them, and take concrete steps to foster a more secure and stable world in which nuclear weapon countries feel able to renounce them. The UK can be proud of a solid record in nuclear disarmament. It has continuously reduced the size of its own nuclear force by well over 50% since reaching their peak during the Cold War, and since 1998 all of its airborne nuclear weapons have been withdrawn and dismantled. Ms. President, members of the Court, this concludes the United Kingdom's first round of oral argument in this case. Thank you for your attention.
Thank you, Ms. Syesil Husna. That brings to an end to the United Kingdom's first round of oral argument. And now I give the floor to the agent of the Marshall Islands, Ms. Shafa Azzahra.
Ms. President, member of the Court, it is a new honor and privilege for me to appear before you as a co-agent of the Republic of the Marshall Islands this time in this dispute between the Marshall Islands and the United Kingdom. My co-agent, Ms. Agent Naura Elnadi, will respond in more detail to the UK legal argument. For my part, in the first part of this opening statement, I will respond to certain misrepresentation made by the United Kingdom in its oral argument. The issues at stake are: 1. The very real grievance issue in this dispute of the strategic agreement. There is the TNP and the policy of the United Kingdom's argument that the remedy should be imposed on its socialites would amount to an extreme slap put on him. 2. In the second part of this declaration, I will refer to the peaceful settlement to which wants to reach my country and the rule of the law that is so important to it. 3. In the last part, I will deal briefly with the Marshall Islands aspect of the compulsory jurisdiction of the Court. 4. As a preliminary point, I would like to confirm that the Marshall Islands do not expect any monetary compensation in this case. Mr. President, member of the Court, the claims of the Marshall Islands in this dispute are based on the conduct of the United Kingdom and its failure to comply with the Article 6 of the Non-Proliferation Treaty since the date to which the international community has recognized the sovereignty of the Marshall Islands. These claims are not based on the behavior of other states or their failure to comply with Article 6. They are also not based on conduct that predates the date on which the Marshall Islands acquired international legal rights. That would be all from me, Ms. President. I would be grateful if you would give the floor to my colleague, Ms. Naura Elnadi. Thank you.
Ms. Shafa Azzahra, I give the floor now to Ms. Naura Elnadi as the co-agent of the Marshall Islands.
Mr. President, member of the Court, it is an honor for me to appear before you again, this time to respond on behalf of the Marshall Islands to the United Kingdom, the respondent in this case. Mr. President, the opening statements made by Ms. Shafa for the respondent certainly helped to clarify the situation in which the parties find themselves in this matter. The respondent, the states, citing the most authoritative source at its disposal, namely itself, that the United Kingdom can be proud of a solid record in nuclear disarmament. Mr. President, the Marshall Islands disagree with this allegation, as this is not about how proud the UK should be about its nuclear disarmament record, but whether or not it's pursued in a good faith and seek to conclude negotiations leading to nuclear disarmament in all its aspects, under strict and effective international control. However, the respondent is not engaged in such negotiation. On the contrary, he was opposite to it and continues to be. The United Kingdom further states, we subscribe to the need to encourage states to make more effort to achieve the objects set out in Article 4 of the Non-Proliferation Treaty, and consisting in pursuing in a good faith negotiation on effective measures in favor of nuclear disarmament. Mr. President, the Marshall Islands also takes issue with this statement.
as it is not a question of whether in the UK is making more or less effort to achieve said objective, but rather whether, yes or no, is pursued in good faith and seeks to conclude negotiation leading to nuclear disarmament in all its aspects, under strict and effective international controls. However, far from being engaged in such negotiation, the respondent is expressly opposite to them. The United Kingdom maintains that there is no dispute between itself and the Marshall Islands. Mr. President, we do not agree with this statement. The UK continues to conduct itself by a rule which is not the one which should be applied in this case. He simply replaced the applicable rule with one that he himself invited in order to be able to claim that the parties are no doubt in agreement. The United Kingdom has never asserted in the context of present proceeding or never, or even, for that matter, outside it, that it was fulfilling fully the obligation which lies at the heart of the present proceeding case. I will therefore state this obligation again, so that the defendant understands what is the subject of this case. Here is an obligation to pursue in the good faith and to connect at the end of negotiation leading to nuclear disarmament in all aspects, under strict and effective international control. Mr. President, member of the court, thank you for patient attention. Here I have come to the end of my presentation, which concludes the Marshall Islands first round of oral argument. Thank you.
Thank you, Ms. Naura Elnadi. Now, a member of the court would like to put a question to both parties, and the question is, at the beginning of this court, one of the United Kingdom's counsel stated, the jurisdiction of the court must be determined by answering the following question. Was there a dispute between the Marshall Islands and the United Kingdom over its compliance with the obligations set out in Article 6 of the NPT, and of any alleged parallel obligation of customary international law on April 24, 2014, that is to say the day of the filing of the Marshall Islands application instituting proceedings? So, can the United Kingdom and the Marshall Islands explain to the court what was on the date of the filing of the application? In this case, that is to say on April 24, 2014, their respective position concerning the interpretation and the application of Article 6 of the Treaty on the Non-Proliferation of Nuclear Weapons, or NPT, and in what context have they adopted it, explicitly or implicitly? The text of the question will be sent to the parties in writing as soon as possible. The parties are invited to reply orally to it during the second round of their oral argument. That brings today's sitting to an end and concludes the first round of oral arguments. The hearings in this case will resume on Monday, 14 March at 3 p.m. with the second round of oral argument. Thank you. The court is adjourned.